ladies and gentlemen. I hope you have enjoyed our local cuisine. Now it is time for us to strike a balance between accused persons and the prosecutions. As you may be well aware, plea bargaining or plea agreement or negotiated settlement, as it is called in some other jurisdictions, is now part of our law, thanks to the Office of the Minister of Justice and Attorney General. But the journey has not been easy. In April 2019, the U.S. State Embassy, Accra, with support from the United States Department of Justice and in collaboration with other justice sectors, hosted a pre-agreement workshop in Accra, Dakar, and other regions. One was held here in Ho to expand the already existing plea bargaining legislation. Some recommendations were made, and one was that there must be a law on plea bargaining, after which there must be a robust public education. Now the law is now in place, so now we have to embark on a robust education to that effect. So this afternoon, ladies and gentlemen, we have one of our own, who is a senior state attorney. He's a product of Wesley Delson. A product of KNUST. She was called to the bar in 2010, and since her call to the bar, she did her national service at the Office of the Attorney General, Kumasi, in Ashanti region. Started as assistant state attorney, and now she's a senior state attorney. Her areas of specialization in prosecution has been in murder trial, robbery, defilement, and rape. She holds masters in law in criminal justice and human rights from the University of Aberdeen, Scotland. She's also a tutorial master in criminal procedure at the Ghana School of Law campus, Kumasi. We have our own sister, Mrs. Akosua Dansoa Asiama Christopher. Please don't be confused. The Christopher is the name of the husband, who is also a lawyer, and we first here. Thank you.
So today we are going to discuss plea bargaining. Okay, so we are going to talk about plea bargaining in Ghana. I want to ask you a question. So if, let's say, you have an office or you have a business, and then you have a store boy over there, and you realize he's been stealing from you, so you report the case to the police, and then it's time for trial. Then you are told by the prosecutor that this store boy is willing to pay the money. Let's say the money is about 20,000 Ghana cedis. He's willing to pay back the money in exchange for a lenient sentence. As the complainant, would you agree? How many of you would agree? Okay. Now, what about if you are counsel for the defense, you are counsel for the accused, and the prosecutor tells you this, but then the prosecutor says, well, we can argue for a more lenient sentence, but we cannot guarantee what the sentence would be. As counsel for the accused, would you take this offer? How many of you would take it? Okay. So I have a few people who say they will still try. At the end of the presentation, I'll ask this question again, and I'll see whether your minds have changed. So what is plea bargaining? According to the Black's Law Dictionary, the 9th edition, plea bargaining is a negotiated agreement between a prosecutor and a criminal defendant, whereby the defendant pleads guilty to a lesser offense or to one of multiple charges in exchange for some concession by the prosecutor. And the concession is usually a more lenient sentence or a dismissal of other charges. So in a nutshell, that is plea bargaining. So in essence, in plea bargaining, an accused person relinquishes his or her right to a full trial in exchange for some benefit. There are three types of plea bargaining. We have charge bargaining, we have count bargaining, and we have sentence bargaining. What is charge bargaining? This is where a prosecutor agrees with an accused person to proceed on a lesser charge than the one originally charged. So let's say an accused person has been charged with the offense of causing harm with the use of an offensive weapon under Section 70. And then the accused person and the prosecutor agree that if he will plead guilty to assault, then if he's willing to plead guilty to assault, then the trial can end. That is charge bargaining. And then we have count bargaining. This is where the accused has been charged with a number of offenses on the same charge sheet. So one charge sheet having different counts. And then the prosecutor says that, or the accused person gives the proposal that, well, I will plead guilty to some if you will withdraw or dismiss the other charges. And so that agreement is made. And then the accused person, in essence, gets a lesser sentence because he will obviously plead guilty to the offenses which have lesser punishment. Then we have sentence bargaining. So in sentence bargaining, the charge is not reduced. The accused person pleads guilty to the offense as charged. So if it is stealing, for instance, he will plead guilty to the offense of stealing. However, he will be given a reduced sentence. So these are the three types of plea bargaining. Now, we all know that there is a new law which deals with plea bargaining in Ghana. Now, I'll give a disclaimer. I'm from the Ashanti region. If I make a mistake and I say plea bargaining, please don't laugh at me. It's perfectly natural. Okay, so prior to the year 2022, there was no law of uniform application for plea bargaining. We had different laws which gave some form of plea bargaining, and there were numerous problems which arose from this because you had to fall squarely under those sections before you could enjoy the benefits of them. And another issue that was there was that none of these sections or none of these laws gave any detailed procedure on what to do when engaging in the loose form of plea bargaining that was being done. So I will touch on some of the laws. Because of the length of the presentation, I will not go into detail. However, the slides will be available on the portal for you so that you can have it as and when you need it. So one of these is the Section 162 of Act 30. And in this case, it deals with when an accused person has been charged with different offenses on different charge sheets. So when he either pleads guilty or has been found guilty on one of the charge sheets, if the prosecutor of the other charges agrees, then the court can consider those charges in punishing him so that it saves the court time. You don't have to go through the whole of the trial. However, the thing is that to enjoy this, the accused person must have committed different offenses and he must have been charged on different charge sheets at the same time. Then we will talk about Section 239, subsection 2 of Act 30. In this case, when a person has been charged with an indictable offense, that person may, and he can lawfully be convicted on a lesser offense, the person may decide to plead guilty to the lesser offense so that he is sentenced. The issue here is your offense must be an indictable offense. So if it's a summary offense, you cannot come under this. And then we have Section 35, subsection 1 to 3 of the Courts Act. And in this case, it allows for an accused person to offer compensation or restitution in exchange for a more lenient sentence. Then we have Section 71 of the Special Prosecutor Act 2017, Act 5959. In this case, where a person is being investigated or prosecuted for a corruption or a corruption-related offense, and then the person is willing to make restitution, or he's willing to give information on somebody, a bigger fish, so to speak, the prosecutor can come to terms with him so that he will get a more lenient sentence for his efforts. And then lastly, we have Section 47 of the Narcotics Control Commission Act 2020. In this case, if a person has been arrested and charged for possession of a narcotic drug or plant, and from the investigations, it comes out that he's working as a courier for somebody else, for a principal, then if the person is willing to give information which will lead to the arrest and charge of that principal, the prosecutor can come to terms with him, and then he may plead guilty to the offense for a more lenient sentence. And as I said, these sections, these laws had some shortcomings. They did not apply to all offenses, as I've said earlier. And they did not give defined rules of how plea bargaining was to be conducted. So there was no uniformity at all. And also, the victims did not have any say in what happened. The victim was not consulted. And as we know, in our criminal justice system, it is the state taking the place of the victim and acting for the victim. So the victim had no say in it. And then there are some cases which have arisen out of some of these sections. In the case of Alhaji Yusuf Al-Hassan alias Obolo versus the Republic, it's a 2014 case from the Court of Appeal in Kumasi. The accused person in his trial for murder had relied on Section 2392 of Act 30. And then later on, so he pleaded guilty to manslaughter, not guilty to murder, but guilty to manslaughter, and he was dealt with. Then he appealed, saying that the correct procedure was not used because it was his counsel that informed the court that he intended to plead guilty. He wasn't the one who personally informed the court, but he was there. So the Court of Appeal said that it did not matter because it was obvious that the counsel was acting on the instructions of the accused. But you see, this could have gone either way. If the Court of Appeal had not agreed and had said that a person must plead guilty personally or it must come from the accused, he would have gone scot-free. And then there's also the case of Raymond Kwesi alias Kwabena Okra versus the Republic. It's a 2020 case. Now, in this case, again, the accused person pleaded guilty to, not guilty to murder, but guilty to manslaughter. When the accused person, the prosecution was left with just the investigator to testify. And on appeal, he said that he was ill-advised to change his plea. And that was one of the grounds of appeal he was going on. But fortunately, when it was time to argue the appeal, he abandoned that ground. But that also shows the danger in the use of Section 2392, where there are no perfectly uniform defined rules for the use of the section. And then there's also the case of the Republic versus Ohenijan versus another. I'll come back to it. And I see some of the older lawyers nodding because some of us at that time, we hadn't been born, but it was a very popular case then. I'll come back to it. But in that case, after plea bargaining had been done, there was an uproar, and the Chief Justice then, during a bar conference, made some statements, and in those statements, he called for a law of uniform application. That was in 1975. And then lastly, we have the case of Republic versus Rex Chachaku and Emmanuel Amekuji. And in that case also, the judge lamented the fact that there was no law for uniform application on plea bargaining because accused persons might have been willing to plead guilty. However, because they were not sure of the outcome of the plea of guilty, they would decide not to do it. So from these cases, it is obvious that plea bargaining or a uniform law on plea bargaining has been sought after for years. And if it is brought up or once it is made, then it will prevent accused persons from, in one breath, pleading guilty to an offense and then in another breath turning around and saying that it was not my deed. There are some countries who already have their plea bargaining laws in Africa, and this is not an exhaustive list. We have Nigeria, South Africa, Tanzania, Kenya, and Uganda. Now, this is the part I've been waiting for. Let's talk about our new law. The name of the new law is the Criminal and Other Offences Procedure Amendment Act 2022. Act 1079. I will just refer to it as Act 1079 or the new plea bargaining law. So what this new law does is that it amends Act 30, and it does this by inserting section 162A to kill in the act. And this new law was needed because our Criminal Procedure Act, Act 30, came out in 1960. That's quite a number of years ago. And then with the evolution of criminal jurisprudence, societal changes, change was necessary. And so it was amended to include plea bargaining. And our law was fashioned after that, or modeled after that of Kenya and the US. Was this act necessary? It was. It was. It provides for a uniform framework in which plea bargaining can be done, so that all the inconsistencies we saw in other cases or in earlier cases could be avoided. And it also does the very important thing of protecting the rights of both the accused person and the victim. We'll see how in a little bit. This new law fits perfectly well into our criminal justice system, especially today, because in order to know whether you would want to plead guilty to an offense or you would want to enjoy the benefits of this act, it is important for you to have an idea of everything that the prosecution wishes to put before the court. And that is where disclosures come in. So with the Eugene Bafuboni versus the Republic case, 2018 by the Supreme Court, and also the practice directions on case management and disclosures, 2019, which mandated the prosecution to furnish the accused persons with everything, every exhibit or potential exhibit in their possession, and even those evidence that they did not intend to tender. This helps the accused person to have a very fair idea of the sort of evidence that is against him, and then it helps him to take an informed decision as to whether to plead guilty or not. And this was one of the aims of the practice directions on disclosures. So with our new act, what is the end result of plea bargaining? It is to reduce an offense charged to a lesser offense. So with the example I gave earlier, causing harm with the use of offensive weapon under 70. And I always mention the section because there is also 69, which is a second degree offense, not a first degree. So causing harm under 70, section 70 of Act 29 could be reduced to assault under section 84. And then it is also to withdraw a charge against an accused person. So the earlier example I gave in count bargaining, so if there are a number of charges, the accused could plead guilty to some and the rest could be withdrawn. And then to also reduce the punishment for an offense charged within the law that prescribed the punishment. So the latter part, I stressed on it because it's very important. It does not just say that the punishment should be reduced, but the section which created the offense and gave the punishment still stands. So if the minimum punishment is 5 years, you cannot plea bargain your way down to 2 years. The sentence will be reduced within the parameters of the law that provided it. And what does it entail? So a charge or a range of charge, a plea agreement provides for a charge or a range of, a sentence or a range of sentences to be recommended to the court. So under this law, you have the chance to negotiate on the actual sentence, and that is very important. And then it allows you to also pay compensation, not you, the accused, to pay compensation to the victim. And it also allows the accused person to make restitution, in which case the accused benefits, the victim also benefits. Who can engage in plea bargaining? The prosecutor, of course, the accused person, and his counsel, if he has one. Also, the prosecutor can only be a state attorney or an officer of the office of the Attorney General. If any other person in any other capacity will engage in plea bargaining, it will have to be with express consent of the Attorney General. So that means the police prosecutors cannot engage in plea bargaining under this act. And these actors, the prosecutors, the accused, and his counsel are the initiators as well. Any of them can set the ball rolling on plea bargaining. And also, the court is not to be involved at all during the negotiations. Now, the form of the plea agreement. When the negotiation is done, they will have to come up with a plea agreement. How should it look? It must be in writing, first of all. It cannot be oral. It must be in writing, and it must be done it must be put in writing by the prosecutor. And then it shall state that the accused was informed of his rights under Section 162C. And these rights include the presumption of innocence, his rights to counsel, his right to a fair trial and a full trial if he chooses not to go on with the negotiations, his right to call witnesses and examine them if he goes to a full trial, and other things. And then it should also state the relevant facts of the case so that anybody picking the agreement will know what the facts of the case are. It should also include any admission which is made by the accused. And then it should, of course, include the charges to which the accused person is pleading so that we know what he is pleading guilty to. And then if there is a recommended sentence, it should state it. Then after it is made, it should be reviewed by the accused and his counsel. And also it must be signed by the prosecutor, the accused, or the counsel, if any. Now, what is the role of the prosecutor in plea bargaining? He has to inform the accused person of his rights, and that is what I was talking about, the right to a fair trial, presumption of innocence, the right to plead not guilty, among others. Let's look at the procedure to be followed when engaging in plea bargaining. As I said, the law provides for a procedure, a laid down procedure to be followed. So any of the initiators or any of the actors can give written notice to the court informing the court of the commencement of plea bargaining. So the prosecutor can do it, the accused person can do it, his counsel can also do it. And when this is done, the court may adjourn for the negotiation phase. Then, before the negotiations commence, the prosecutor, and this is very important, the prosecutor must furnish the accused person with all documents to be disclosed. And these are the documents as mentioned under the Practice Directions on Disclosures 2019. So the charge sheet, the facts, all statements, any, I'll take a deep breath, any exculpatory evidence, which is any evidence that could help the accused in his case. And anything that the prosecution has. And if it is in the form, if the exhibit is in a form that cannot be logically filed or given to the accused, then the prosecution must give him the chance to come and view it so that he has everything, he knows everything that is necessary for him to know. When this is done, then negotiations will begin. The negotiations are supposed to be completed within 30 days. After 30 days, if the negotiations are not completed, the court may proceed with the trial. But this does not preclude the parties from continuing with the negotiations. And this is obviously to prevent accused persons from intentionally holding up the court proceedings. So he'll say, I want to engage in plea bargaining, let's negotiate. And then you are negotiating for 8 months and nothing is coming out of it. And then when the negotiations are concluded, if a plea agreement has been reached, then the prosecutor, as I said earlier, will put it in writing. And then within 7 days, he has to file a copy in the court and then serve same on the accused, his counsel, and the victim where applicable. So you see, the victim is coming into the process. And then the court may exercise its discretion in admitting a plea agreement out of time. So the fact that for some reasons the prosecutor is not able to file it within 7 days does not mean that all is lost. The court can exercise its discretion in their favor. Then, when they go to court after all this has been done, the court will question the accused under oath as to whether he entered into the agreement voluntarily. The court will question him. And then the court will also find out whether he understood his rights as the prosecutor explained to him in under section 162C of the new act. So the presumption of innocence and all that I mentioned. And that the court will also find out whether the accused understands that by entering into this agreement, he has waived his right to a full trial. There will no longer be a full trial if the process is completed. And then he also has to find out whether the accused understands the nature of the offense to which he is pleading. So the new charge to which he is pleading under the plea agreement. And then he will also find out whether the accused understands that by accepting the plea agreement, he's waiving his right of appeal. If the accused indicates that he understands all this, then the prosecutor will read the plea agreement to the court. And then if the court finds it necessary, the court will hear from the victim or the complainant. The court may then accept or reject the plea agreement. It is discretionary. If the court decides to accept the plea agreement, then the court will call on the accused to plead to the new charge. If he pleads guilty, the court will record the plea and convict him. If he decides not to plead guilty, then that means he is withdrawing from the plea agreement, in which case the trial will proceed. If the trial is now about to start, the trial will commence. If the trial reached a certain stage and they had to stop or adjourn for the negotiations, the trial will continue from the time that they stopped. And then where the court has accepted the plea agreement and the accused person has pleaded guilty to the charge, then the court will consider the recommended sentence. It is a recommended sentence. If there is no recommended sentence, then the court will impose a sentence as it deems fit. If the court is satisfied with the recommended sentence, the court will sentence the accused person in accordance to that, and then everyone is fine. But if the court is not satisfied with the recommended sentence, then the court will advise the parties to go back to the drawing board and renegotiate so that they can see the way forward. So I said that the court may accept or reject. So where the court rejects the plea agreement, the court will make an order for the trial of the accused person on the original offense charged. And as I said earlier, the court will not engage in plea negotiations. Now, I said one of the advantages of this new act is that it helps the victim as well. So what is the role of the victim? So the victim or his representative must be informed about the plea agreement, and they should be allowed to give their opinion on the contents of the plea agreement. But what about if the prosecutor searches for the victim or the complainant and cannot find them? This does not invalidate the plea agreement. And also, if the victim or the complainant objects to the plea agreement, then they may put their objection in writing, and this written statement will be filed as part of the plea agreement. So you realize that the fact that the victim or the complainant objects does not mean that plea bargaining should stop or the negotiation should stop. They will air their views in writing. It will be put together, and that forms part of the plea agreement, and the court will consider all that in accepting or rejecting the plea agreement. Then in considering the plea agreement, the court may question the victim or the complainant about any objections which they may have, and the court may take these views into consideration. Take the views into consideration. It does not mean that the court will do what the victim is asking, but at least here the victim gets a voice. The role of the investigator. So is the investigator lost in all this? No. A prosecutor cannot conclude a plea agreement unless he has taken the views of the investigator into consideration. And this is logical because it is the investigator who has met the witnesses. He has seen the evidence. He has been to the crime scene. He has heard stories about the accused or seen witnesses who have spoken about the accused. So it is necessary for the prosecutor to hear from him before completing a plea agreement. Now, safeguards for the accused. As I said, before considering a plea agreement, the court will address him personally under oath and find out whether he has been informed, he has entered into it voluntarily, being informed of his rights, and that he's waiving his right to a trial. And then also the court has to find out whether the accused is of sound mind. Whether the accused is of sound mind and whether he entered into the agreement voluntarily. That part seems very important to the act. And then whether there is a factual basis for the plea agreement. I will come back to the definition of the factual basis later on, or the lack thereof. Whether there is a factual basis for the plea agreement. Now, when the court rejects the plea agreement, the court must record his reasons for the rejection and then inform the parties of the rejection and the reasons. And then he'll enter a plea of not guilty for the accused. Then he'll make an order for the original trial to proceed. When the court rejects the plea agreement, there is no right of appeal against that decision. There is no right of appeal against that decision. Rather, new negotiations may be carried out by the parties. And also, after an accused person has been convicted based on a plea agreement, he has no right of appeal. He cannot appeal against the plea agreement which he himself has entered into. However, he has remedies. He may apply to set aside the judgment on certain defined basis. If there is fraud, misrepresentation, undue influence, mistake, duress, illegality, or incapacity, or if the rules of natural justice were breached. If an accused person decides to, if one of the parties decides to set aside the judgment, how do they go about it? It is by a motion supported by an affidavit. And then he has 90 days from the date of judgment to file this motion. And then the Attorney General and any other person affected by the application must be served. So the victim or the accused, if it is the Republic which is trying to set it aside. And a party who receives it may file an affidavit in opposition upon receipt of the motion. When a person who files an affidavit in opposition may be cross-examined in court to find out other things or to find out the reasons behind his opposition. And then the court also has the power to call any witnesses whose evidence may be relevant in the matter to testify. So for instance, the court may decide to call the investigator in the case to question him on certain things to find out whether truly there was fraud, misrepresentation, and others. Then when a case is correctly set aside, then the court may make an order for retrial. A person who is aggrieved by the decision of a judge in an application to set aside the judgment may then appeal against that decision to set aside. So that is when there is a right of appeal. There are certain offenses which are excluded from this new act. Treason and high treason, high crime, rape, defilement, genocide, robbery, kidnapping, murder, attempted murder, abduction, piracy, hijacking, and election-related offenses. These acts are excluded. These offenses are excluded from the act. I will have a question for you on that. Now, what are the skills that are needed for plea bargaining? Ample knowledge of the offense charged. If you have no knowledge on the offense charged, how do you plead it down to something else? You need ample knowledge on the offense charged. And your negotiation skills must be good in order to go through the process of plea bargaining. And then another point is that as a defense attorney, it is imperative that you keep going back throughout the negotiations, you keep going back to what the evidence that you have been given, so that there are some things you may not have averted your mind to at the beginning of the negotiations, but after disclosures, when you put certain things together, you might find out that, oh, it even looks like the prosecution does not have strong evidence against my client. Let me withdraw from the negotiations. I think I can fight this in court and get my client an acquittal. I can't believe I just said that. Okay, so let's move on. What are the benefits of plea bargaining? Plea bargaining benefits the accused. It benefits the state. It also benefits the victims. There are disadvantages as well. So, as we have said, it can end up in the withdrawal of a charge, in which case an accused person may get a lighter sentence. And there may be with a reduction in the number of charges which have been brought against the accused person if he pleads guilty to some in exchange for the withdrawal of others. Also, there can be a reduction in sentence when he engages in sentence bargaining, pleading guilty to the offense as charged, and then getting a lighter sentence for sin. There's a certainty of sentence. Certainty of sentence in plea bargaining, and that is very important. I witnessed a case in court where an accused person was charged with murder, and he pleaded guilty to manslaughter under section 2392. And you know you cannot recommend the sentence. And when it was said and done, he was given 25 years in prison. And I felt that the accused person, from the facts of the case, he could have fought his case and he could have won, because it was a jury trial. And the facts were such that he had been attacked in his shop by the deceased, and an altercation broke out and he killed him. So he might have gone under the provocation plea, provocation defense. But he got 25 years. So there is a certainty of sentence in plea bargaining. And also, the benefit of this is that if you don't know what you can be given and you engage in plea bargaining, even if there is no recommended sentence, at least you get a lighter sentence than what you expected, because this man that I just talked about was facing the death penalty. He got 25 years. At least it's something, isn't it? You don't agree? I think the room is filled with defense attorneys. Okay, so the avoidance of stigma also. The accused person avoids the stigma of having his wrongdoing talked about in public, since trials are publicized. And then a speedy trial. He doesn't have to spend so much time in court fighting his case. The victim or the complainant also gets compensation and restitution, or restitution if that is one of the terms of their plea agreement. And then the victim or the witnesses are made comfortable, because not all witnesses feel comfortable testifying in court. Some are afraid, so they're able to avoid that. And then also there's a certainty of punishment. The victim knows that the accused will definitely be punished for what he did to them. And then for the defense attorneys, there's a reduction of caseload, but somebody told me that is not a benefit because the caseload makes you money. But for me, it's a benefit. Then trust. If you are able to get your client a lighter sentence, it raises his trust in you. Then benefits to the state. There is a reduction in caseload for the state, so that, and with this goes hand in hand with prioritizing cases. You're able to prioritize the cases which involve more. And then there's an assurance of punishment for the accused. And prisons, it may lead to the decongestion of prisons, and this will help especially if we start having a regime for non-custodial sentences. And then the accused person may be reformed, since he gets a lighter punishment. He knows what he did is wrong. He's not let go free, but at least he gets a punishment and it is a lighter punishment so that he doesn't spend so much time in prison being corrupted. And then restitution may be made to the state in corruption cases as well, and other perpetrators may be arrested. Now the criticisms. And a lot of, I won't go through all of them because a lot of these have been taken care of by the new act. So the Dr. Ohinijan case I talked about, it was a lawyer who was charged with the murder of a person, and later he pleaded guilty to manslaughter and was given a lighter sentence. And the public did not understand. They felt because he was a lawyer, he was dealt with leniently. So some people may believe that plea bargaining allows perpetrators to avoid punishment, but this is not so. And penalizing accused persons who plead not guilty, but under the new act, that will not exist. Also, confusion of accused persons. An accused may be confused and may plead guilty to an offense. However, under this new law, with the judge asking him whether he entered into the agreement voluntarily and all that, ensuring that his rights have been dealt with, this does not exist anymore. Now, there are a few gray areas in the act which I want to touch on. The explanation of factual basis. So, to accept a plea agreement, the court has to see whether there's a factual basis for the plea agreement. The factual basis has not been defined. So, it is taken that it might have to be on a case-by-case basis. But this, I believe, goes against the uniformity that the act is planning on bringing, because you don't know what each court will decide as the factual basis. And then we also have the restitution and compensation. The law is not clear on when restitution is to be made. And as a prosecutor, I would prefer restitution is made before the accused person is let go. Because if you let him go, how do you get him? So that was not made so clear in the act. And then also the relationship between sections 162R1 and 162R4. So 162R1 talks about the exemptions that I talked about, and 162R4 talks about the fact that a person who has been charged with an offense which is punishable by death may plead guilty to a lesser offense. Which offenses are punishable by death? Murder, treason, and all that. They fall under the exceptions. So how does it work out? And how do you juxtapose this with section 2392 of Act 30? So lastly, our takeaway from this is that plea bargaining benefits all of us, the accused, the victim, the complainant. The new safeguards are there to eliminate some of the disadvantages that existed for plea bargaining. And very importantly, the victim or the complainant cannot hijack the system or the process, because though they are given a say, they cannot stop the process. And it is important that the public understands plea bargaining, and the AG has said that there will be public education on this act, and that will help to set the ball rolling on the act. So before I end, let me ask my question again. If you were counsel for the defense and your accused wants to plead guilty under this act, you can negotiate on a recommended sentence. Would you want to go through a plea agreement under this act? May I see by hands how many would want to? Still? Thank you very much.
Thank you. Before I take your questions and comments, as I've said, the U.S. Department of Justice, through the U.S. Embassy Accra, play a major role in fashioning out this piece of legislation for us. May I take this opportunity to introduce our learned friend from the U.S. Bill Hauser is the resident legal advisor. He succeeded Michelle Jackson, who started this whole process of fashioning out this piece of legislation. And we have Alan Collier from the Global Justice Institute. And then we also have Paul Gill, who is the intermittent legal advisor. They have been with us since yesterday and here because of the particular interest that they take in this subject that we have just discussed. May I now take your questions? So now we know that Section 162 of the Criminal Procedure and Other Offences Act has been amended. Yes. Your name and then the question.
Okay. So, on the recommended sentence, it's a negotiation. So, the parties negotiate. The accused may come up with the sentence he's coming up with. The prosecutor may also agree or disagree, and then it's a negotiation on the sentence between the two of them. And with your second question, it is answered under Section 162, I think A1, or yes, I think A subsection 1, where it talks about the fact that the sentence may be reduced, but within the offense creating section, within the section that created the offense. So if it is, for lack of a better example, if it is rape, for instance, I know rape is excluded, but if it is rape, for instance, you cannot recommend a 4-year sentence because it goes below the minimum. Yes, that's why I said for lack of a better example.
Thank you. Next question. Yes. David. Is that?
Hello.
Yes.
Hello. The mic is here.
Question from here.
Yeah,
Yes.
the mic is here.
Yes.
Thank you very much. I don't know whether I heard you well. Did you say that where an accused person...
Please, your name first.
Sorry, I'm Gary Nimakon.
Very well. Yeah.
Did you say that where an accused person and the complainant have voluntarily agreed on the terms, the judge by himself decide to set it off and not agree? Did you say that?
Yes.
And
that's the law.
Well, I mean, but if the parties are not disputing, under what basis can a judge show motu decide to adopt the terms?
There may be collusion.
It doesn't make sense to me, because as an accused person, I'm the complainant. All right, we've sat down.
Let me answer you. So what it is that this is a sort of safeguard. Sir, this is a sort of safeguard for the rights of the parties involved, so that prosecutors don't do this. We are straight. But in case a prosecutor wants to connive with an accused and put something together, the judge has the right to look through the agreements they have done, go over it, and then see whether it is okay. Let me give you an example. In case, let's say, an accused person is a repeat offender, and then for an offense for which the maximum is, let's say, 25 years, he's a repeat offender, and they are recommending a 1-year sentence, 6-month sentence, for instance, the courts will not agree to that, and that is a valid safeguard.
My concern is that the complainant is not complaining.
It's not about that.
Not complaining.
The public interest must be safeguarded.
Thank you. We'll take the last two questions. Last two. Yes, please. Any female? Yes, I see a lady's hand, please. Let's do some gender balancing here.
Question is in relation to the 90-day limit for filing the motion to contest the plea agreement. I just wanted to know, because there's a provision for extension of time, for instance, to appeal, is there any applicable provision like that in this instance?
Okay, so in this act, there is no applicable provision. And the thing is, we can also not use the provision for extension of time for an appeal, because this is not an appeal you are doing. This is setting aside, it's a motion. So that I would say is one of the gray areas that we would find in the act.
Just a short follow-up. So the question was having in mind the situation where sometimes convicts might not have the opportunity to engage counsel for one reason or the other. So even if we don't specifically have extension of time being in contemplation, is there any other provision that might give some room for?
As I stand here, from my reading of the law, no. And off the top of my head, no. However, there is a provision that says that rules may be made by the Rules of Court Committee, and then the AG may also give rules for the procedure to be carried out. So maybe that is something that can be thought of.
Yes.
Hello.
Last question.
Okay.
Yes. Your name, please.
My name is Anthony Edu Nketia, aka Tony Short.
What is the person asking the question?
My question.
I can't even see the person.
Hello.
Okay. Yes, please go ahead. Ask the question.
Okay. My question is in twofold. The first one is that I think the law has failed the accused persons, in that if there is no right of appeal, but then the person has been ill advised by counsel, how is it that when this information is brought to the attention of an appellate court, he cannot be given a remedy? And the law simpliciter says there's no right of appeal. Secondly, I want to know why a judge who is not part of this negotiation will be given the discretion, specifically the accused person, to disclose everything that will have been to his defense. And now for the judge to reject the agreement that he has signed with prosecution. Would that be fair?
Okay, so I'll take your first question first. In relation to okay, so I don't remember. Okay, so your last question first. In relation to why the court has the right to reject the plea agreement, and there's no right of appeal, I mentioned the factual basis, and also the accused person. There are safeguards for the accused. That is why when the accused is put before the court painstakingly finds out, do you know the offense to which you are pleading? Do you know the consequences of this? Do you know the consequences of the agreement you've entered into? Was it voluntary? If through all that you couldn't tell the court that I've been ill-advised, then on appeal, why should you be given that chance? And also, in relation to why the accused person has disclosed everything which will be to his defense, and the court is rejecting the plea, the plea agreement. I've explained why the court is allowed to reject the plea agreement. And I will add that the Act states specifically that whatever is in the plea agreement, whatever confessions the accused person made during the negotiations should not be used against him in during the proceedings, in case he withdraws or in case the I know you will say that the judge is human, so he will consider it. But even if he does, that is why you write a judgment, a reasoned judgment. He will have to explain his position, and that would be difficult.
Please, this is just the beginning of the public education. We may continue at other fora. Thank you for coming.